Hello everyone, happy Friday and welcome to today's webinar on Crash Course Contract Law. It is day one of our 5-part series, and today we will be learning about two topics. One of them is scope, price, and time, and the other one is payment terms and conditions. My name is Ingrid Velasquez. I am the Chief of Content and Marketing for Folio. Some of you may already be familiar with me, and some of you are also Folio users already. I am seeing a lot of familiar names here today. For those who are not Folio users, we are a platform for architects, designers, engineers, contractors, vendors, and basically everyone in the design build industry. Folio makes product specification easy and efficient, and our software also helps streamline the creation of product schedules, purchasing, invoicing, creating documents, and more. If you would like to know more, please go to folio.com. We would be happy to set up a one-on-one demo with you. So today we have with us Wally Zimolong Esquire. He is a lawyer for the real estate and construction industries. He has successfully litigated hundreds of cases and has counseled clients all over the country on developing and constructing highways, multifamily apartment buildings, professional and collegiate sports stadiums, schools, and uniform plan communities. He has also tried numerous cases to verdict and so far has an undefeated jury trial record, which I think is pretty badass. So after Wally's lecture, I do also have a short presentation of my own, and it'll be about a few tips on how to keep track of fees and payments that are due to you and how you can make getting paid easier and faster. Our goal with today's webinar and the following sessions of this 5-part series is not to turn you guys into lawyers or have you be more knowledgeable and educated than lawyers. Rather, we would like to help you be more familiar with contract language, and especially language that puts you or your firms at risk. Also, please don't take this as us helping you protect yourselves against contractors or against designers or subcontractors. Instead, think of this as a way to help everyone be on exactly the same page, since this is what Folio is all about, so that everyone knows what they are agreeing to and everyone's interests are protected. Ultimately, the goal today is to prevent contract disputes because that's no good to anyone. And one single case that goes to court, even if you win, is probably enough to drain anyone of their assets and livelihood. So before I hand the presentation over, please remember that you can type in your questions in the little question box on your screen, and we will have answers for you after the session. And without further ado, here is attorney Wally Zimolong.
Thanks a lot, Ingrid, and thanks a lot for everybody that's joining here today. As Ingrid said, my name is Wally Zimolong. I've been practicing construction law. I hope everybody can see my screen okay without the audience view, the GoToWebinar box. If not, I'd ask somebody to speak up or just send me a message so I can respond. But as Ingrid said, I'm a construction attorney. I've been practicing for almost 20 years. I can't believe it's gone by that long. I'm actually in my 18th year of practice, but I've spent my entire career representing contractors and developers and design professionals, and you name it. I've represented folks on in disputes for $2,000 up to several million of dollars. So I've seen it all, and the one common thread that runs through all of the disputes I've worked on in my career is it really all comes down to a matter of contract. And I often tell clients that a dispute, as far as the time and expense that goes into litigating a case regarding a construction project, doesn't necessarily have anything to do with the amount in controversy. It has to do with with what the facts are in the case, and that that's important because it just underscores the expense that goes into litigating a case involving a dispute over a contract. And I'm often, I'm often called by clients uh, to address disputes after they've happened. And it's much more frequent that I'm called in to give my opinion and render my assistance for clients over a dispute, a contractual dispute, after the dispute has arisen, after the contract is signed, and after either the work is underway or the work has been completed. And if I had one piece of advice to give my clients and give anybody else that was calling me, is that I would say an overwhelming number of these disputes could have been avoided if the client had reached out to me first and had me review the contract and review the terms and conditions that they were agreeing to. And I understand that it can be difficult, and it can be, I'm as much a small business owner myself as I am a practicing attorney, and I can understand how hard folks work to get clients and how difficult it is to get and maintain clients, and in the rush to secure a client or get a new customer, it can be easy to overlook just exactly what you're agreeing to when you are engaged by a new customer, as opposed to taking the time to review the relationship that you're getting into. And we often lose sight of that, and we focus solely on the economic aspects of it, and in the rush to sign that new customer, forget about some of the details. So this series, as Ingrid said, is really a chance for all of you to get familiar with some of the stuff that I've seen in my 18 years of practice. What I consider the most common areas of dispute and causes of the dispute in the construction industry for design professionals and others. And today we're going to start with price and time and payment terms of a contract. And before I go any further, I just want to make sure that I feel that my screen is probably not in the best position for everybody. So I just want to take a second here and recalibrate my slides. I apologize. I think that's the view I wanted to give everybody. Okay. So scope, price, time, and payment. These terms seem and appear so basic and so fundamental. You may be wondering why we're even spending any time talking about it, but you would be surprised how frequently we see disputes arise in these four main areas. The four most fundamental things in a contract. What are you going to do? What will you be paid to do? How will you be paid to do it? And how long do you have to do it? And it's amazing, like I said, how frequently disputes arise in these areas. So let's talk about scope. Scope is simply what you have agreed to perform for your customer and what is your client agreed to pay you for. And you need to be clear in the contract specifically what services you're going to be performing for a client and what services you will not perform for a client without additional compensation. Where I see the biggest mistakes in this area is that a client requests a proposal, and for the most part, you set forth in a clear and an understanding basis what it is you're agreeing to perform and what it is that is excluded from your proposal. And then that proposal gets affixed to a larger contract, which the client sends back to you. And very few people actually read the contract that is sent back to them, assuming that their proposal has been accepted, their proposal is attached, and everybody is clear as to what the scope of work that is agreed to be performed is. And you countersign the contract and you're on your way. What you often see is that your proposal conflicts with the terms and conditions of that larger contract. And it's amazing. I see this problem on projects big and small, several $1 million projects and small projects. And it's often very discrete language that causes a very large dispute. It could be simply something like there was a type of permit or a type of tax that was excluded from the proposal and wasn't set forth in the proposal, but may in the contract may be stated that you've agreed to pay for those or front those costs for a client. So you need to be clear about that. And if you could take one lesson away from this webinar today, it is don't simply allow your proposal to be attached to a larger document. Make sure the scope of work in the larger document accurately reflects the proposal that you've presented to the client. And if it doesn't, you simply have to ask the client to cut and paste your proposal and put it in the body of the document. So now that you know and we've clarified what you have agreed to perform, you need to define what is included in your contract price. Clearly, you've agreed to perform a certain scope of work in exchange for a certain dollar value of payment. But is it clear in your contract what your customer will be paying you for? Because it often is not. Is the price that the customer is going to pay you for your labor and material and supervision only? Or do you anticipate your client paying you for things such as taxes, bonds, your insurance, and as I said before, things like permits and fees? You may think that that's an understanding that the client is going to reimburse you for that, but it's always best to make sure that it's spelled out in the contract. And the reason for that is, and I probably should have stated this at the outset, is most people have heard the term get it in writing. And that's just not something that we have as a term of art or something that we colloquially will say. It's in fact the law. And what the law is that if you have a written agreement, the courts are going to look to that written agreement as the manifestation of the intent of the parties. And very rarely is the court going to entertain evidence as to what the parties thought or what the parties said to each other, even if what they thought and what they said to each other prior to or contemporaneous with the execution of the contract, even if it conflicts with what the contract says. So it's not enough for you to say, well, I know it doesn't say that specifically say that the client's going to pay me for my for permits and costs that I front for the client, but my client told me that don't worry about it. He's going to pay me for it, or she's going to pay me for it. That's not going to fly because the court's just going to look at the contract and say, I'm sorry, Mr. or Mrs. Smith, you don't have that in the written agreement, and I can't entertain what was said outside of the contract. So that just underscores that point. Now, next, we need to talk about time. If there's one term in a contract that I see most frequently admitted, it's time. Everybody more or less has something that discusses what the scope of work is. Of course, in a written contract, I don't think I've seen a written contract yet that doesn't have some price that the client has agreed to pay and you've agreed to accept in performance of that work. Obviously, if you're not clear, there may be a dispute later on as to what's included in your price. But I've never seen a contract without a price in it. In fact, I don't even think you'd really have a contract if you didn't have a price. But time, how long is it going to take you to complete your scope of work, is frequently admitted. In fact, except for larger contracts, such as, or more robust contracts, such as those that are a standard set of documents, consensus docs, the American Institute of Architect family documents, AIA documents, time is frequently admitted, and something with a completion time is the exception. A contract with a time for completion is the exception rather than the rule. In fact, we often see in the more sophisticated and robust contracts that have a specific provision for someone to include a time for completion, that it's often left blank, or that the time for completion is not consistent with when the contract was executed and doesn't simply give the contractor or design professional a reasonable amount of time to complete the scope of work that they've agreed to perform. It's simply an oversight. So you need to understand that if there is no time set forth in the contract, courts will read in a reasonable amount of time into the contract. What is reasonable? Well, it's going to depend on the facts and circumstances of the particular case. And it's also going to take you cost you a lot of money to prove what is reasonable, because reasonable is a subjective term. It's fact sensitive. That means if you get into litigation, there will be discovery. And with discovery, you have increased costs. So do not assume that there is a mutual understanding that your work is anticipated to take a certain amount of time. Moreover, if there are delays on a job that have nothing to do with you, you should get an adjustment in the time it takes you to complete the contract. You should not be held to an unreasonable completion date. So if you are in the situation where it's the exception rather than the rule, and there is a completion date included in your contract, make sure it's reasonable, and make sure when you receive your notice to proceed from your client that you can complete the contract and the scope of work set forth in your contract in the time frame that the contract has provided for you. Because again, the contract is going to be used as what the parties intended the agreement to be. So if you're in the situation where the time frame set forth in the contract perhaps isn't reasonable, perhaps you were not noticed to proceed because of some delay beyond your control, and the client says to you, don't worry, I'm not going to hold you to the contract completion date, that's not going to be enough. You're going to want to have a written amendment to the contract that memorializes that contract completion date. So I've given you so far just sort of a general overview. If you could just take 3 points, look at the scope, look at the price, look at the time, and make sure they're reasonable, and make sure they include everything you believe they need to include. There's nothing that says a contract can't be too specific or too precise, and no one's ever going to hold you to that. Now I'm going to move on to some, I don't want to, I struggle to use the term esoteric, or maybe some more specific contract clauses that you may see, and particularly in some more sophisticated contracts. And the reason I've chose the following is because they relate to some of the lessons that I just talked to you about scope in particular. And the first clause that you need to be aware of in your contract, and where it may conflict in the area of scope, are those clauses known as flow down or incorporation by reference clauses. Now, what you'll often see in a contract is that the contract will say that the terms and conditions of the contract not only are those that are set forth in the printed terms before you, but it will reference other documents. It could be the your client's agreement with the owner of a construction project. It could be the contract drawings or some other body of documents that aren't available to you before or before you when you're reviewing it and deciding whether to sign a contract. Okay. However, if there is a flow down or incorporation by reference clause, those terms and conditions will become just as binding on you as the terms and conditions that are set forth in the physical document that you're being asked to sign. Now, the problem for that is, I think, pretty obvious, is if you don't take the time to understand what else is being incorporated into the contract, you may find yourself agreeing to a whole host of things that you're completely unaware of. You may be agreeing to a much broader form of indemnification. You may be agreeing to certain dispute resolution procedures that you did not think you were agreeing to, termination provisions, and how your claims get processed. You also may be agreeing to a different scope of work than that which is set forth in your proposal. And if you've been paying attention, that you've done a good enough job to incorporate in the main body of the document itself. So you need to be aware of what are called flow down and incorporation by reference clauses. They are quite common in construction industry contracts, and some of you may also be familiar with them. And if you see those types of clauses in your contracts where they reference other documents, besides which those are before you, you should request them and review them as well. Just because you didn't have them at the time doesn't give you a defense that they're any less binding on you. And in fact, I've even seen contracts where it said that by signing it, you've either reviewed those third-party documents or waived the right to do so. Now, what about payment? And when I mean payment, when and how are you going to get paid for your work? When, meaning in what time frame after you complete your work and you submit your invoice will your customer be required to pay you? And also, how is it that your customer is required to pay you? And I don't mean cash or check or some form of wire. I mean, what are the prerequisites that you need to achieve to be entitled to payment? Is it simply that you have performed? Does your work need to be approved by a third party? Are there documents that you need to sign in conjunction with submitting a request for payment? So that's what I mean by how. How are you going to get paid, and what things do you need to do to check all the boxes to get paid by your customer? Now, in this area, one of the most frustrating clauses, I think, for those that are uninitiated, folks unlike you that have sat through a seminar like this, comes in the form of something called pay when paid and pay if paid clauses. Now, there are two distinct types of clauses in a contract. They both relate to payment. One is much more onerous than the other, and because it's much more onerous, it has the potential to be much more impactful to your business and your cash flow. So when we discuss pay when paid clauses, we are simply referring to a timing mechanism in a contract that sets forth when you will receive payment, within how many days after your customer receives payment does that payment need to be remitted to you? Is it 10 days? Is it 15 days? Is it 20 days? And what's important, and the distinction between a pay when paid and what we're going to talk about, a pay if paid clause, is that it does not condition payment to your customer, or does not condition your payment on your customer receiving a corresponding payment. So that's pay when paid. Much less onerous, not too damaging to you, just gives your client a little breathing room as to when it needs to pay your invoice. Not so with pay if paid clauses. A pay if paid clause is considered a condition precedent. And what that means in the law is that something must happen before your client is obligated to pay you anything. And that's something that must happen before your client is obligated to pay you is that it must receive payment from its client. So if you're working as a subcontractor or for somebody that is not the owner of the project, this is where it's going to become critically important. Because when you're working as a lower tier subcontractor or someone else that's not in direct contractual privity with the owner of the project, you're down the payment stream. The owner holds all the payment and disperses that payment to the persons that and entities that they've entered into contracts with, and then those persons or entities will disseminate payment further down the payment food chain. Now, if you're in that type of situation, there is frequently clauses known as paid if paid clauses that says that if that person up the food chain does not get paid, you don't get paid. And that person with whom you maintain a contract with has no duty or obligation to pay you, even though you may have completed your work in a good and workmanlike manner, you've submitted all required documents to receive payment, and have done nothing wrong other than being unlucky enough to be down the payment food chain where on a contract where there's a pay if paid clause. Now, that may seem unfair, but the way the courts look at this is they consider it a risk shifting provision, and it shifts the risk of loss of non-payment by the owner or the higher tier contractor to the person that agreed to a pay if paid clause. And to some respects, contracts, but it's particularly in the construction world, are as much a duty and obligation document as it is a risk shifting document. Who holds the risk of various incidents that can occur in the course of construction on a project? And one of those risks is the risks of non-payment. Now, pay if paid clauses and the interpretation of them and the enforceability of them do vary from jurisdiction to jurisdiction. I primarily practice in Pennsylvania and to a lesser extent the state of New Jersey. But each jurisdiction you need to be familiar with whether they're enforceable and to what extent they are enforceable. In Pennsylvania, they're absolutely enforceable. In New Jersey, they are enforceable, but to somewhat of a lesser extent. Unfortunately, I don't have a 50-state survey of what the enforceability of pay clauses are in your jurisdiction if you're not practicing in one of those two jurisdictions. So it's important to understand that. I am just giving you a sort of a general overview of pay if paid clauses, and it's important to understand that this general knowledge can be tweaked from jurisdiction to jurisdiction. So because the understanding of this pay if paid clause is so important, and in fact, I would say that this is the number one clause. If you could change one clause in your contract upon reviewing it, it's pay if paid. Because frankly, you're not in any good of a situation, no matter how much money the contract is worth to you, if your customer is under no obligation to pay you and you don't meet your cash flow obligations. You're not going to be in business very long, even if you have several contracts, if you're not receiving cash flow. So if there's one clause you could ever change in the contract, it's pay if paid. So, or just be aware of it and know the risks of getting involved with a project that has it. You might not be able to change it, and it may just be something that you have to live with in order to perform work on that particular project for that customer, but you should understand it. So what do you need to do to understand the difference between the two? Well, sometimes it's a subtle difference, as you can tell, maybe you can tell from some of the discussion I've been providing you. But look for terms such as condition precedent, if and only if, or unless and until. So for example, if it says that your payment is not payment by the owner is a strict condition precedent to payment to you, you can be pretty sure that's going to be considered a pay if paid clause. If it says that your customer does not have to pay you if and only if its customer pays it, you can be pretty clear that's going to be construed as a pay if paid clause. If your contract says that your payment isn't due unless and until your customer receives payment from someone else, you can be pretty sure that's going to be considered a pay if paid clause. So if you don't get, if you have that and you don't get paid, and that hasn't been modified, no matter who the lawyer is, he or she's going to have a difficult time trying to pry payment away from your customer if you have a pay if paid clause, because they're generally valid clauses and they're quite onerous. And as I said, if there's one thing that you could leave here with today, knowing and understanding in a contract that I'd like to see changed for clients on a frequent basis is pay if paid clauses. So that brings us to the end of my short webinar presentation on scope, price, time, and payment provisions of a contract. And with that, I'm going to turn this back over to Ingrid. And after her short presentation, we can open it up to any questions and answers.
All right, thank you so much, Wally. That has been super eye-opening. All right, so let's jump really quickly into just a few tips into how you can set up your dashboard so that you can get paid more quickly and you can keep track of your payments more easily. So before I actually go into that, really quickly, I would like to show the non-Folio users what the dashboard looks like, just so they know what I'm talking about when I switch to my presentation. Okay, so there are two basically components today of Folio that we are going to be focusing on. One is the dashboard. More importantly, the columns in the dashboard. And the other one is going to be accounting. Right there. Okay, so let's get started with this. Okay, so what we're going to talk about today, hopefully you're going to learn ways to stay on top of all of the payments that are due to you, whether it's for a service or whether it's for products or if it's for fees that you have to pay for permits or things like that. And then we'll also have tips for how to keep track of work that is already finished. This will tie into what Wally was telling us about prerequisites to getting paid, especially if you're a contractor or subcontractor. Basically, this is a way to mark to keep tabs on what part of the job has been finished so that you can claim payment for it. And last but not least is tips on invoicing so that you can send an invoice to the client as soon as possible and get paid as soon as possible. Okay, so let's dive in. Pricing columns. This is something that if you've been using Folio, you are already familiar with. Some of these are default, some of these can be set up custom depending on what you need. This is a typical setup. So let's say for a really high-end couch, you guys may want to keep track of what the retail price is and also what the trade price is and how much the client is actually going to pay for it. Something that you can do to keep track of labor that has already been, a way to keep track of how much labor costs is to set up columns for labor. Like for example, if you have ceramic tiles that need to be installed, you can set up a column for that and put in, whoops, how much the rate is and the number of hours that it took and the total for labor. So that's one way. And then you will also want to set up columns for fees and permits, like so, just so you can keep track of it. And then you can also set up columns for whether the work has, well, basically these are status columns. A default list that we already have whenever you sign up is a list that will say something like, you know, this product is in, selection is in progress, or this has been submitted to the client, or it's been approved by the client, or this product has been sent back to the manufacturer, or things like that. But you can also add items like this has been installed. And then another column that you might want to set up is whether you already issued an invoice for the labor that has been done, or if it has been paid. Okay, so in invoicing, there are going to be default items like retainer fees, design consultation fees, and all this, which you can easily add to an invoice that you are sending out in one click. So make sure that you also have that you add items for, you know, for labor, for installation, and things like that. Okay, so what happens then is if you have all of these things set up and like Wally said, and the prerequisites to getting paid have been fulfilled, like let's say the paint has been, you know, that like they've finished with painting the entire kitchen and they've installed tiles in the powder room on the ground floor and things like that, then you can, as soon as that work has been finished, you can send an invoice. Because as you know, when you send an invoice like today, it might take a few days to get paid, and the sooner you send an invoice, the better your chances of getting paid early. So what you'll have to do is just click add service, and it'll add an item like so right here. You'll just need to edit that according to how you charge for these items, and then you can send it out to your client, and hopefully you know, you're able to click paid for this section of the work. So if you want to learn more about that, you can either call, email, or visit us on Folio.com. Just get in touch with us and we will schedule a demo with you. And all right, we can, all right, that's the end of my presentation. We are now opening the floor for questions. Do you guys have any questions for us?
Easy crowd.
I know. I mean, there were a lot of details there, and they might need some chewing over. Or oh, okay, here we go. Something from Catherine Schumann. How detailed do you recommend we go on our scope?
Well, like I said, I think you should go as detailed as possible with your scope, specifically calling out those items that I think are particularly not included in your scope of work that you may be concerned about, that that someone may anticipate you including in your scope or paying for. Conversely, making clear that you're going to seek reimbursement for that. There's nothing. No one's going to fault you for being too specific with your scope of work. So, use your intuition. Anything that you're concerned about, or you say, I don't want to be stuck doing, should be something that you put, not included in scope, excluded from scope. So some separate paragraph in some form that calls out whatever it is that you don't feel that you should perform, or you're not agreeing to perform unless you are compensated a different amount.
Yeah, to quote Wally, you can't be too specific and you can't be too precise.
No, you really can't.
Okay. All right. There was a question from Diane, but I guess that got answered as well. So contractually, scope stating what we will and won't do is a good proactive practice.
Yeah, absolutely. Absolutely, Ingrid. That's like I said, that's one of the things I wanted to drive home. And then, to go back to what we said in the presentation is that, if you spend all this time being specific and being precise on what your scope is, make sure it jibes and melds with the larger document that you may be requested to sign. Whether it be that your proposal is attached to a larger document, you want to make sure that it doesn't conflict with the terms. And frankly, if you submit a proposal, I sort of, I'd be remiss if I didn't say this, is that I was working under the assumption that in a lot of cases, and it's frequently done, that a proposal gets attached to a contract, a larger contract. But it just as well as if you submit a proposal and then you get back a contract that you're requested to sign and your proposal isn't referenced in that contract in any way, your proposal doesn't really mean anything, because as I said, the court's going to look to the written contract that you signed as to what you have agreed to perform, and it's not going to necessarily consider what your proposal says. And in fact, there's often language in the contract that says any documents or any discussions or anything else that was exchanged or talked about prior to the execution of the contract that you're going to put your pen to is essentially out the window. So be wary of that. Don't spend all the time preparing the proposal and just assume that by signing the contract, your proposal has somehow been incorporated into the contract.
Awesome. So it looks like we're we keep going back to a few salient points here, in that, it's always going to come back to what is written in the contract, and it's always going to be what exactly was written in the contract and what is not written there, and that's what's going to matter at the end of the day if a contract dispute does happen.
Yeah, it really is. It does. And you just can't. You got to spend the half hour or an hour going over your contract and not be hasty in trying to get it back to a client to either appease their schedule or just in the rush to bring in a new customer. In fact, I was just dealing with a client, a sophisticated client, the other day, and they were dealing with a customer that was based in Georgia, and they were based in New Jersey, and I asked them, they wanted to know if they could sue the customer in New Jersey because they owed them a lot of money. And I said it really depended, and I said, well, first, do you have an agreement with them? And to my surprise, they weren't really even sure. And then they said, well, I think we do. I think we have something that they presented to us and we signed. And I said, well, could you send it to me? And we found out that in the contract, it said that all disputes had to be resolved in California. So the customer was based in Georgia. My client was based in New Jersey, and they had a contract that said that they had to bring litigation in California, which is a a binding provision except for certain exceptions. But it was probably something that the customer that sent them that proposal didn't even know. It's all too common that people pull contracts or boilerplate things off of the internet and think and don't even spend any time reviewing it themselves. But now this client who's owed a lot of money is faced with the prospect of having to sue this customer in California because neither of them took any time to read the document that was presented 2 years ago at the inception of the relationship.
I do have a follow-up question for that, but first let's go to Catherine. This is a really, really good question because I see it a lot in interior designer forums. So Catherine says, I am an interior designer. Is there a best method for estimating time on a project? We tend to run into clients who either move smoothly through the project or who drag their feet, shop on their own, etc., and really drag out the timeline.
Well, I could sympathize with the interior design world for two reasons. One's because my wife is in the industry; she's an interior designer, and I'm always telling her, you have to bill like me, which is you have to account for every minute of your time, and that can be very difficult. But that's the only way that you're really going to get paid for the value that you put into a project. And there's not much similarities between the interior design world and the construction law world, except for the way clients take advantage of our time, so to speak. So yes, I mean, I feel your pain because I have clients that do the same thing, and then like I said, it gets close to home. I think you need to be cognizant of two things. First, if you're billing at an hourly rate, like some designers do, then you just need to be unbelievably disciplined about your timekeeping and how you bill. And otherwise, you're leaving money on the table, and you're really letting the client take advantage of you. Alternatively, if you're working for a client under a firm fixed price proposal, when you're putting your proposal together, you need to be aware of the fact that clients often do that, and that especially in today's world. I mean, I think what goes lost in the world where in professional services where time is essentially our product as much as our knowledge. In today's world where folks exchange text messages and emails and have questions for you at all hours of the night, and they, that time adds up. And that time to me is something that you should be compensated for. So I'd add that. Now, as far as your specific question about clients sort of circumventing you and kind of taking your ideas and shopping on your own, it's a little bit beyond the discussion that we had today. But I think there are certain contractual terms certainly that you could include in your contract that would prohibit your client from doing that, or if your client does that and you find out about it, they would compensate you in the same way that they would compensate you if you had procured the product yourself. If I know I often, like I said, just from my personal experience, interior designers can get a product at one price and they sell it to the client at another price, and part of their compensation is the delta at that price. It's almost like the standard clause in a real estate contract with a real estate broker. If the real estate broker lists your house and then you go out and say, thanks a lot, go advertise the house, but someone that they bring to you calls you on the side and says, hey, let's cut the realtor out, let's do a deal together. That realtor is still going to be entitled to their commission. So it would be a similar clause to that.
All right, from Diane. This is a really good question. So regarding this topic that we were talking about just now, is a clause for client indecision, stalling, non-communication, halting work with LOA stating the consequences okay?
If I understand the question correctly, if a client stalls or doesn't give you a decision on something that is stating in the contract some sort of consequence of that, okay? Is that the question?
Yes.
Yeah, certainly. Yeah, you can put whatever language in the contract you want. I mean, I sort of have that language in my agreements with clients. You know, if you don't get back to me and you don't provide me guidance on what it is that you'd like me to do in the direction you'd like to take your case, then I can terminate the contract for you. And one of the later things that we'll talk about, you know, and again, this is only the first part of a series of webinars. We only discussed the topics of price, scope, time, and payment provisions today. But I believe one of the future webinars will discuss, you know, things like termination. So how do you get out of a bad deal, right? How do you get out of a bad deal with somebody if you just got a nightmare client, and what you can do to protect yourself?
Very good. So Catherine says, thank you for this fantastic presentation. Are you available for hire outside of Pennsylvania and New Jersey?
Yeah, it depends. It depends on the scope of what that you're looking to have done. You know, for transactional type stuff, like I said, contract review and type of things like that. It's not necessarily a jurisdictional specific thing that I'm prohibited from assisting clients outside my core locations. You know, if it requires some sort of court appearance, that gets a little trickier, but doesn't necessarily preclude me from doing it. It just gets a little bit more complicated.
Awesome. So going back to Diane's question, again, it looks like it all just boils down to what is written on the contract and what both parties specifically agree to. So, you know, yeah, you can definitely put together any sort of conditions and things like that, which would be super helpful for clients who do drag their feet. So yeah, I think a lot more people are going to be interested in getting in touch and asking for advice. So please tell us, Wally, how we can get in touch with you.
Yeah, sure. I think if you're looking at your screen now, I mean, all my contact information is in the lower right-hand corner. I mean, the best way to get in touch with me is via email. My email's there. It's Wally at zimolonglaw.com. Website's on there. I also have a blog that I've had for about 7 years. It's I'm told a great resource for folks called supplementalconditions.com. It's got some videos of me, as Ingrid's showing. I've been trying to do some more video blogs so you can see what I look like in person. And but there's also a lot of written content, and again, it goes back 7 years. So there's actually a ton of content on there and resources. And sometimes I think I put myself out of business. And people can get answers to a lot of questions by reading my blog, and instead of having to call me and engage me. But I like it. It's fun. People tell me they enjoy it, which is important.
Awesome. All right. So if we don't have any more questions, I think that's all the time we have for today. I really do want to thank everyone for coming today, and I'm seeing on my control panel here that a lot of you, the majority of you, were super duper attentive and interested today, and you had some really good questions. So personally, I'm super happy with how this all turned out. Please join us for the next 4 sessions. The next one is going to be on Thursday at 1 p.m. Eastern. So same time, but on Thursday. And bring your friends. If you have any questions from today that you remember to ask on that day, please feel free to do so, and get in touch with us. Get in touch with Wally for questions. And yeah, thank you so much, everyone, for being here today.
Thanks a lot, Ingrid.
Thank you, Wally. Okay, bye.
Take care. Bye.